Hi there, this is Jonathan Ginsberg. I'm a Social Security Disability attorney in Atlanta, Georgia, and I want to talk to you about hypothetical questions that the judge is going to ask the vocational expert at your Social Security Disability hearing. And if you haven't yet gone to the hearing yet, what you'll find is that the judge will in many cases have a vocational witness there. The vocational witness is typically a person with experience or knowledge, education about jobs in the economy, and is going to testify for the judge about jobs that you might be able to do given the limitations that may exist in your record. So for example, after taking testimony, the judge will turn to the vocational witness and say, Mr. Vocational Witness, assume we have an individual the same age, education, work experience as our claimant. Assume further I find this individual is limited to light work with the following non-exertional limitations. This individual should avoid all unprotected heights and hazardous equipment, should avoid fumes, odors, dusts, and gases. This person should be limited to simple repetitive tasks that do not involve significant changes in the work site, et cetera, et cetera. And again, based on this question, could this person return to past work? Could this person do any other kind of work? And the vocational witness will testify accordingly. And obviously what you're looking for, what we want to have happen is the vocational witness to testify based on the limitations you've described, Your Honor, in this hypothetical. There are no jobs that I can think of that I'm aware of that this person could do. And that's what we want to do, because that means obviously you're disabled. So basically we're trying to get to that point. And obviously as an attorney, I'm going to prepare you and ask you questions so that if the judge accepts your testimony as true, then there are no jobs you could do. And my question that I'm already going to have prepared is going to really reflect your testimony and those limitations. But inevitably what's going to happen at the hearing is the judge will ask a number of questions. Sometimes the answer is going to be, Your Honor, I can give you jobs in sedentary, sit-down type of work. I can give you light jobs. I can give you medium jobs, and really go through a whole number of different jobs. And you come out of the hearing, well, what is that all about? This person said I could be a toll taker on a tollway, an expressway. They said it could be a hand packer. The vocational witness said I could be a foil wrapper or something like that, or a surveillance system monitor. What does all that mean? And I get a lot of questions from people saying, I went to my hearing and the vocational witness said I could do all these jobs. What does that mean? Well, basically, it may mean a lot, it may mean nothing. And the reason for that is that some judges will ask a lot of questions, starting with a question where clearly there are jobs that exist, and then kind of move steadily over to the point where there are no jobs. And the reason the judges are doing this is because what they're being looked at, their decisions are being looked at, and so they want to show the appeals counsel or anybody looking at their decision that they considered all the evidence from every angle. Maybe they looked at your limitation and they started out with, well, what if your physical limitation is mild but your mental health limitation is a little more severe? Or what if your mental health limitation is severe, but I think your physical limitations are very mild? And so they'll go through, kind of the whole exercise to try to come up with sort of where that line is. And if you're above the line, you're disabled. If you're below the line, you're not. And realize that judges are trying to come up with really as close to that line as possible. They're trying to figure out, they don't want to assume more than's in the evidence. So they want to come as close to what the evidence would show and that can be justified as possible. Sometimes they're doing that to cover their own behind. To create a paper trail that will cover their own behind. Sometimes they really don't know what the vocational witness is going to say. I mean, I'll tell you, my experience has been that most judges know pretty quickly what they're going to do, and they kind of base their hearing and their questions around that. But sometimes they really don't know what they're going to do, and they want to find out by asking these questions. So really, I think what you want to talk to your attorney about is, what is your attorney's sense from the questions? Sometimes if you've been in front of the same judge, that if he asks, a lot of questions that get, 15 jobs as a response, that's not a good sign. Sometimes that means the judge really is just going through the exercise, and based on the last 2 or 3 questions, he's going to approve you. So it really depends on the particular judge. But the reason they're asking all those questions is they're trying to figure out, where that line is, and how close they can get it, so that they can figure out, are you disabled? And if you're just over that line, he wants to approve you, but he doesn't want to do so in a way that assumes too much. And if he's going to deny you, he wants to do so in a way that gives you the benefit of the doubt, that even if he found you have moderate limitations here, you still could possibly do some work. So, from your perspective as the claimant, what you want to do is, when you testify, when you practice with your lawyer, you want to identify very, very specific work limitations and put some time frame to it. In other words, you don't want to say, I can't sit very long, I can't stand very long, I can't lift very much. Because when you try to plug that into a hypothetical, it means nothing. But if you can say, 3 hours a day, at least 4 days a week, the pain in my back is so severe that I cannot function at all. I have to lie down and take pain medications, which puts me to sleep. You can plug that 3 hours a day, 4 days a week into a hypothetical question, and obviously, if you're missing that much time from work, it's going to be very hard for you for the vocational witness to find jobs you can do. That's why preparation is so important in Social Security cases, and identifying specific work limitations that you cannot perform is so important as well. So I hope this has been helpful, and I hope this helps answer that question, so that you can really pose it. It's not a question that you can give an answer to without knowing the judge, but you'll know how to pose the question to your lawyer, and also maybe a little bit of advice about how to prepare better for your hearings. Again, my name is Jonathan Ginsberg. I hope this has been helpful. Any questions you have or you want me to answer, please let me know, and I'll be seeing you soon. Thanks a lot.